guys, Leslie Sultan, estate planning attorney. Just waiting for my guest, Christina Sammartino, to come on. We are going to be discussing a celebrity. So we announced that we're having a mystery celebrity, and then we revealed that it's Jerry Garcia of the Grateful Dead, who I was a fan of. All right, so again, we're using this book, Trials and Heirs, which gives us a great resource for learning about celebrity estates. All right, so as most people know, Jerry Garcia was a guitarist for the Grateful Dead. He died in August 9th, 1995 at 53 years old of a heart attack in a rehab facility, drug rehab facility. And he was married to his third wife at the time. Her name was Deborah Coons Garcia. So we will get to the other wives later. But basically, he left behind his wife, and he did do estate planning. So that's the good news to share, is that Jerry Garcia did do a will, and he named his wife as the executor. So that means she was in charge of the estate. But what followed was until 2001. So we're looking at 6 years of an open estate with numbers of creditors coming after Jerry Garcia. And his wife basically said that, she came on board not even knowing what an executor was. And by the end of it, made, I think it was hundreds of thousands of dollars as in her role as executor. And had to deal with a lot of estate issues. So maybe that's where you could come in. Do you remember some of the estate issues that she had to deal with?
Yeah, so, the first thing, which is big for a lot of people, is that there was very little cash at hand in his estate. So the majority of his estate, which was valued at $15.4 million, was in non-liquid assets, such as royalties and other assets. So we face that a lot in our practice, is that a lot of times we have clients where their only asset is a home, is real property, and they leave it to their children. And sometimes their children don't want to sell the property, but there's creditors. And that's what happened in this instance, that Jerry Garcia had several creditors. We look at creditors for a couple of thousand here, maybe, a few thousand, but his creditors were substantial. He had one creditor who asked for just about $5 million. And that was his second wife. Her name was Carolyn Adams Garcia, but she was also known as Mountain Girl. And her creditor claim was that way back when, during one of his performances while on tour, she handed him a piece of paper that said that as part of their divorce, he agrees to pay her $250,000 for life.
And why her life, not his life, her life.
Yeah, huge distinction. His widow, the executor, obviously opposed it and lost. The judge upheld it and said that it was a valid divorce agreement, and that because in the past he did pay her $250,000 a month, he had made a few payments and a total of $400,000, that he kept up with his promise and that it was valid. Even though his widow tried to argue impairment because of the drug use. So that just goes to show you a few things. A lot of times with divorces today, we work hand in hand with a lot of divorce attorneys as well, because if you have that in your agreement that your spouse is supposed to pay you X amount of dollars for the rest of your life, it's super, super important that you have something as collateral. So you should force your ex to obtain a life insurance policy for a certain amount of a certain value, so that if, God forbid, something happens to him or her, you'll still get paid. That's a big one today. I've seen it in the past is, oh, well, you owe me $100 a month for the rest of your life, for the rest of my life. But what happens if you pass away before me? Yeah. Another big issue was one.
Just on that, though, I did want to point out, so this was a handwritten note that was only one paragraph. I mean, you would never get away with this in surrogate's court, because there's all these rules around what a will has to say. So if it said, when I die, I want her to have this as a will, that would not have been valid. But because she used it as a divorce agreement, one paragraph, handwritten, signed presumably under the influence of drugs, she got away with it. So keep that in mind when you're getting divorced.
Because the executor did appeal the judge's decision, and so instead of going through lengthy appeals and probably spending more on attorney fees, they decided to settle for around 1.5 million. So a lot better than paying the 5 million that she was looking for, but still 1.5 million out of his estate. The other issue was that he had a lot of people who claimed to bear his child or have his secret love child or somebody who was his child. And so a lot of that kept his estate in the courts. Today, meeting with an attorney, updating the attorney as time goes on, creating family trees while you're alive and putting it in your file with your attorney will also help. It will help to prove that, this so-and-so child is not truly a child. The other issue was with one of the children. They felt that the child support that the mother was receiving was not substantial enough, and that should be paid off the top. Different creditors have different rights. Each creditor holds a certain
hierarchy.
So, your executor, your funeral, your attorney, your accountant fees all get paid off the top. And then, Medicaid is a big one that gets paid before other creditors. And in this case, one claimed that because the child support obligations had not been met, that they should have been paid first before any distributions were to be made. So his estate trickled on for many, many years. I think it said that it finally ended in 2008 when they finally came to an agreement for the child support issue. So he died in 95 and it didn't end until 2008. So could you just imagine how his poor widow could not only not grieve the loss of her husband who died at a young age, but now had to be bombarded with these creditors and these crazy claims and fight them off.
Do you want to talk about what the creditor limits are to bring a claim against an estate?
So creditors have 7 months to make a claim against the estate. So there's a little bit of a misconception there that's it. They only have 7 months, and if they don't bring a claim, that's it. It's done. Well, that's not necessarily true. First, if the executor administrator knows of a debt, then that puts them on notice. So the 7 months wouldn't apply. If for some reason, though, a creditor does not make a claim against an estate in the 7 months, they're still able to make a claim against the estate, except the executor administrator cannot be held personally liable if they already made the distributions from the estate. So I'm the executor of my mom's estate. She's got $100,000. 8 months pass. I know of no creditors. I've checked her mail. I made sure no creditors file a claim. I distribute the money to myself and my siblings. And now in 8.5 months, a creditor comes and makes a claim. We will have to try to pay it and negotiate it. But if my siblings don't want to give me the money back and I don't want to give the money back, it's harder for the creditor to win than if they would have made the claim within 7 months. So, everybody has to do their due diligence. I tell clients all the time, you wait the 7 months so that you get in the statements and you get the mail and you can see if there's a credit card bill. You can inform all of the credit unions and they will then send something out if there's a debt out there. So everybody has to kind of take and do their part and be responsible. One of the things it talks about is, an executive administrator is what's called a fiduciary, and they have certain obligations that they must meet. They're bound by those obligations, and if they don't uphold them, they could be in breach. So it's really, really important that if you're a named executor or if you want to be the administrator of somebody's estate, that you hire an attorney and you work with that attorney and, you let them help you step by step of the way so that you don't miss anything.
Good points. So the only good news really is that because the wife, Coons Garcia, was the executor, she was entitled to like a commission or a fee. And she earned that fee. And said in 2001, she received a salary of $450,000 for all the work that she did. So, that again was 6 years after he died. So we don't know what the other years look like. But, that was a benefit she received that came out off the top. And it was in addition to whatever she was entitled to under his will. But that also goes to show that if you, have a lot of creditors and a lot of issues that could be open, and you've named an executor, but you really want all your money to go to children, that money's not going to the children if it's getting paid to the executor first. So I thought the most important point of the Jerry Garcia thing is, even though you have a will, you have to update it and speak to your attorney about what could be going wrong. What divorce agreements did you possibly sign? What kind of new creditors could there be out there that we need to plan better for? You guys, well, thanks for joining us. We hope this was informative. So just keep in mind, if you haven't done an estate plan, you should do one. And if you've done one and it's been a little while, we recommend doing a review every 3 years, or whenever there's been a substantial change. So, we recommend you speak to your attorney in those situations. All right, guys, thanks.
Bye, everyone. Thanks for joining.